we talk about the native customary land. So that is the legislation, Land Code 1958. But today I will concentrate more on the adat, creation and establishment of NCR based on the adat. And I see a few lawyers around here who are very knowledgeable on particularly on the Land Code. The topic that I'm going to talk more today is the role of adat in establishing a right to the land, particularly on the practice of the indigenous people. I include here, firstly, the books where you can read the history of the adat, the migration of the indigenous people from other parts of the world to Kalimantan and to Sarawak. For all you know, Borneo is an island, Pulau. So the relationship with history and the adat migration, what I call the historical evidence. On top of that, I will also talk about the physical evidence relating to the creation of right. So for those of you who are familiar, I am happy about it. I know some of you are very familiar with the adat. And for those who are not, my dear brothers and sisters, I'd like to share something that are not familiar to you, particularly on the terms or the terminologies. In court, we always bring about terms and terminologies which you will not find in the legislation or in the statute. And that is why there is always a dispute over the terms. The government of Sarawak in particular, they always question these terms. Many a times in court, they question what are these terms. To them, to many of the lawyers who do not know the terms, the practice, the adat of the indigenous people, they are very not happy about it. So if you read the books or the article written by the late Tan Sri Gurun Lembat on adat and land, article written by Encik Jael, the book written by Eric Jensen, the book written by Derek Freeman, Michael Heppel, Robert Pringle, and many more others. They will talk so much about the customs, tradition, leading to the creation of right. That is why we talk about custom and tradition interchangeably with adat. Adat means custom and tradition. And what is custom? Custom is the practice of the people. Custom is adat the practice of the people. So anyway, I've written the paper on this. I know the time space is very limited, so let me go to the main point. Pemakai benua. This has been a very hot subject. Pemakai benua, you don't find it in the statute, you don't find it in the legislation, the words or the terms. But this term has been used by the indigenous people, by the Dayak, by the Iban. In fact, if I mention about the Dayak or other races, you look at it, the interpretation ordinance, you will find that. And Iban came about quite recently. So it's a bit misleading. If you talk about si Dayak, it means Iban. Then Dayak means Bedayu. And the Orang Ulu, I don't know that's in the constitution. So I hope you are familiar with these terms. Now, pemakai benua is the terms used by the Iban to, the definition. Let it be clear that Adrian Richard defined pemakai benua as an area of land held and used by distinct community, which include farms, gardens, fruit groves, cemetery, water, and all forests within half a day's journey. Agent Richard, the former resident of Semangam, and many other writers, Dr. Professor Dimak, defined pemakai menua a territorial domain of a longhouse community where customary right to land resource was created by pioneering ancestors. Now, pioneering ancestors, earlier on I mentioned about the migration from Kalimantan up to Sarawak here. The people who first settled in this land, they are called the pioneers. And these are the people who bring along with them the adat to where we are today. That adat is still very much alive. But to those of you who do not understand the adat, many of you might think this adat is something that is too small to understand. But the importance of adat to the indigenous people is very, very important. It talks about the livelihood. It talks about the way of life. It talks about custom and tradition. So land to the Dayak community is very, very important. And that is why no matter what, no matter how difficult it might be, when we go to court, we must make sure that the right of the native people on the adat, based on the practice just now, talking about the terminologies of pemakai menua, these are all very important matter to us. We cannot take it lightly, we cannot take it so small a matter until we forget about it. But young people, yes, I'm very fearful, I'm very scared, I'm very worried that young people might not understand what is adat. Many a times you encounter, or they say, why talk so much about adat? We have the common law, we have this law, that law. There is certain law that you can depend on. Common law, yes, but the customary law, which you don't talk, which you don't see much in the legislation and the statute, still practiced by the people. And this is important when you defend your right. Then the process of creating the pemakai menua is interesting, which you don't see now. Because after 1958, there was the cut that time. After 1st January 1958, you cannot create right anymore, native customary right. No way. Anything earlier, yes. But the process of Pangol Menua, and this is very interesting. Pangol Menua, it means this is the ritual done by the pioneers, people who first settled in particular area. After the Pangol Menua was done, only then can you create right. You can fell the trees, you can clear the area to make farms, gardens, or any other land tenure system, like penam or cemetery, or even a longhouse site. Before you do this ritual, you cannot settle there as you like. The leader of the pioneer, in those days, they are the war leader. Today, they are called Tuan Rumah, because there's no more war. Pangol Menua is very, very significant. A leader in that particular group will establish the settlement. If there are already communities earlier than them, there has to be boundaries drawn. These boundaries are not drawn by GPS as it is today. I'm talking not about the GPS government. I'm talking about the gadget that will survey the land. So the boundaries drawn by way of the ridges, the mountain, the valleys, the streams, and then this is how the landmark, how the people in those days draw boundaries. Within a longhouse, there is antara umai or antara kebun. Boundaries are very important to determine that your right is so much, and other people's right is so much. Now, many a times we are asked in court why the pemakai menua of certain community is so big, can be 2,000, 3,000 hectares. How do we know this? We know this when we come to court as Saudara Janantau is there. Then the land survey come up with their figure. we come with our own figure by using the NGO who is surveyed. The reason why we have so much what we call it pemakai benua. One, some areas are for farming, for gardening, and for other use. And some land we don't utilize, but we keep them there so that we can go there and gather what we need, the domestic need. And this is what we call pulau. Therefore, within pemakai benua, there is pulau, there is pendam, there is temudak, there is umai, there is garden, and so on. There is pulau buah. Now, all these important tenure system to the Dayak communities are very important. Why are they important? I go back to my point just now. We depend on land for livelihood. We use land, we utilize land. Not every part of the land is for farming. Some land we keep, we reserve, we preserve. The word pulau, if you look at the definition by A.J.M. Richard, if you refer to a land in the sea, the island surrounded by the sea, but if it's the land, pulau can be individually created. It can be communally created. Pulau refers to an area where it can be surrounded by the farms. It can be created by the community for the purpose of gathering, hunting, water catchment, and so on. Pulau is very, very important. Until today, there is so much dispute about pulau by the government, by the company. I'm afraid I have to say this because these are factual. We have this problem. The issues affecting the people who have the NCR land is very serious, my dear brothers and sisters. Very, very serious. And apart from the issues, we have the challenges affecting the community. Let me tell you about the PL. Up to the year 2005, somebody has compiled the number of leases. Almost 1,000 leases. We put it in terms of acreage, several thousands hectares, several 100,000 hectares of land already taken in the form of professional lease. And this is serious. Out of this 900, almost 1,000. There was up to figure to 2005. More than 400 of these PL were brought to court. In other words, the landowners, the NCR landowners, bring the matter to court to sue the company, to sue the government. The last over 20 years, court were very, very active in the trials. How we knew about this? Personally, I'm involved with BC Chihau, with Baro, Saudara John Antau, Paul Raja, Archen Ngau, and many other lawyers. Every month, every week, we go to court. Because this problem is not a small problem. When your rights are taken by somebody, you have to act. You have to defend your right. Now, what is very unfortunate here is when the PL is given, many a times the land are not properly surveyed, not demarcated. PL means you are given the authority. I mean, somebody is given authority, up to you to survey how big the land. Then you tell the government, oh, is this 4,000, 5,000 hectares. In other words, there is lack of consultation. There is lack of prior informed consent. And this is the word of the United Nations. There must be prior informed consent before you take people's land. So this is very important. Let me read to you what the United Nations says. Listen carefully. This is what the United Nations Declaration of the Right of the Indigenous People. Article 32, very, very clear. One, indigenous peoples have rights to determine and develop priorities and strategies for the development or use of their lands or territories and other resources. Number two, states shall consult and cooperate in good faith with indigenous peoples concerned through their own representative institution in order to obtain their free and informed consent prior to the approval of any project or project affecting their land or territories and other resources, particularly in connection with development, utilization or exploitation of mineral, water or other resources. 3. States shall provide effective mechanisms for just and fair redress for any such activities and appropriate measure that shall be taken to mitigate adverse environmental, economic, cultural or spiritual impact. Now, that brings me to a point when the state government of Sarawak developed hydro, HEP, hydroelectric power. There was Batangai, hydroelectric power, there was Bakun, Murum, and then Bengoh, and to be built now in Baleh, and the one that proposed but cancelled is Baram. Now, thousands of hectares of land have been submerged by the water. Bakun as big as Singapore. Mind you, how many thousands of hectares already sinking? You don't see that the NCR is no more there. And so it's Batangai, and so it's Bakun and Murum. Now the effect of this development, so-called development, the people are displaced. They have no more NCR. In Batangai, personally I'm affected. We are given only 11 acres of land per family. And not all land are arable, not all land are good, some are rock. Mind you, Bakun is only 3 acres per family. 3 acres is only 1.1 hectares. I'm not sure about Murum. Now, each and every one of these mega projects, before they implement, the government must have a EIA study. One, they have conducted socio-economic study. But, mind you, after all the mega projects were done, we have not seen what evaluation or assessment study done on all these mega projects. My point is, whether these projects are successful or failures, it's very important to know. Because millions of money spent on developing this project, millions. But mind you, my brothers and sisters, the impact or the effect of this hydro is very, very difficult on us. Number one, land never grow, human being keep on growing. In Batangai today is almost 40 years, I think. For 40 years we have been moving there. Extended families keep on coming. Where do the extended family make a living? When the land is so limited, divided by so many families. So there is no future expansion. There is no long-term kind of planning where NCR has been affected. We cannot go back to our original land because it's already submerged. So this is something that I want to share with you as YPG Health. Dr. John just now was saying, once we form the government, I know Saudara YPG Nikarayong said it, our President said it, when we form the government, please do something about what are the future of our people, particularly those who have been resettled. And those who are resettled, YB himself been resettled. The Sekrang resettlement scheme, Jagau, Mungun, Tada, Squaw, many people have been affected. And I've been to all these areas. The condition of these people whose land have been taken by the government, and here they are being resettled. I liken it to be like a chicken with a chick living in a very small place. Chicken not bad. Night time they are in a cage. Daytime they be set free. But human being, if we don't have such a big area where we roam, where we make a living, life will be not only difficult but getting more and more difficult. Coming back to my point just now, what has the government done to mitigate all this pain, to mitigate all the problems faced by our people? The land has been taken, so many thousands of hectares.
Suara Sarawak, is it?
We'll be talking about, when land are taken, there should be proper compensation. In the federal constitution, when you compensate, it must be adequate. Some of the land have been compensated by the company or by the government, only a few hundred per acres. There is no consistency in this. There is no standard or recorded standard amount. Batangay, when we move, the best one given 600 per acre. I am from the second base. Ours is only 350. So the land is not far from each other. The base one, 600. Base two, we move to second base. 350 per acre compensation. So there you see the government is not very consistent about all this. So anyway, these are among the challenges faced by our people who have been affected, where our NCR have been taken from us. Now there's so many instances, so many problems that arise from our land that being taken. Now I want to share with you the dispute happened between the people and the company, and the people and the gangsters. I have to say this, brothers, I have no fear and favor, but I have to tell you this because these are the facts that have taken place that make the relationship with the government, the people, quite bad. Okay, let me roughly mention. Longgang, Ulu Blaga, 1992, 42 natives were arrested, charged because of criminal trespass for disobeying police order to disperse and protesting their land logging company encroachment. They defend their right, but at the end of the day, they were being caught. Number two, Sabatu Nia in 1996. They made a police report for the company's encroachment to their land. The police refused to accept their report, instead harassing and eventually arresting the villagers. Okay. Number three, Ulu Baram, 30 Penans alleged beaten indiscriminately by the police and 4 arrested trying to negotiate with a logging company against encroachment. 4 subsequently charged in court for illegal assembly. Tiga Baram, 1997, Magistrate Court imprisoned 3 natives who are part of a larger group of natives peacefully defending NCR land from company intrusion and their property from destruction by company workers. Sungai Pong, 1997, 42 natives arrested and they were tortured, beaten by police while under detention and classified them as prisoners of coercion detained solely for peaceful defense of their NCR land against commercial development. Rumah Busang, Rumah Bali, near September 1997 to 1998, oil palm company encroached into NCR land. Villagers protested and lodged police report. Villagers patrolled their own land to safeguard it from intruders, but eventually clashed with gangsters. Sent by the company to intimidate them. 4 gangsters were killed with further 3 injured. Sungai Sebuti, Bakong, 1997, violent confrontation between villagers and police. 4 natives were shot, 8 policemen injured, 1 native fatality with death. Nur Anak Nyawai, 4 natives sued pulp and paper company for trespassing and damage to NCR land. Native won a historic court judgment while recognizing NCR claim of Dayak native as legal, which is accorded protection under the current law. Surya Anak Muntai, 2012, slashed by enforcers employed by a plantation company, illegal extracting timber. He was the target of the gangster as he is one of the local leaders who strongly defended their right. Tuai Rumah Ismawi was shot by the gangsters. Michael Wang arrested for fatal shooting of gangsters. Now, these are among the few cases. The most recent one, if you heard the last few days ago, there was in Tanjung Manis, where there was a big encounter with the company, and the authority come to help the company against the Iban Day. I was there recently trying to help them in court. Now, there was one case 2 years ago in Semunyan. I was fortunate I happened to be there. There's so many cases where the confrontation between the native, the companies, and the authorities. I want to share with you, my brothers and sisters. I have one which I did not make the police report. I was called by people from Sarawak in Nia. I went there, and along the way, I saw a lot of cars somewhere in the oil palm. I thought they were fighting somewhere. I did not hear any I did not hear any noise. I presume these are the people who've been employed by the company trying to confront the Iban. When I reached the destination, I saw a lot of the Iban were there, young and old. They are waiting for these people to come. Now, I don't like people to fight. I don't like to see people fighting each other. I don't like to see that race against race.